Joining me now to break down how serious the breach of security was and Mr. Trump's possible legal exposure are former U.S. Attorney Chuck Rosenberg and the former lead prosecutor in the Mueller investigation, Andrew Weissmann. Both are NBC News legal analysts. Welcome to both of you. Thanks so much for being with us. So, Andrew, first to you, let's talk about those three laws. The three laws that are potentially, violations written in the search warrant. Talk to me about them, because this whole issue of whether he declassified or didn't declassify really is immaterial to those three laws that they cited.
Yeah, that's absolutely right. I do think it's worth noting that with respect to the Espionage Act, although it is technically immaterial, it does require it to be national defense information. And there is an argument that the classification system is what fills in and provides gloss to what that means. So that's probably, from Donald Trump's perspective, the one where if the documents were in fact declassified, that's a large if, where he would have the best argument to argue that that statute shouldn't be charged. But the other two statutes don't require in any way that the documents be classified. And the most surprising statute that we saw listed is the 1519 obstruction statute. That potentially could be quite significant, because that's the kind of crime that really exacerbates the underlying crime of having these documents. And, at the department, when they're going to consider whether they should charge the former president, the fact that there may be obstruction of justice, and that is lying in addition to having these documents improperly at Mar-a-Lago, I think will weigh quite heavily, as it has with other cases that they've brought in the past, for instance, against General Petraeus. And
Chuck Rosenberg, the New York Times has reported, and we have not independently confirmed this, that a lawyer for Donald Trump actually affirmed in writing to the Justice Department after the search that everything had been turned over, or rather after the June 3rd meeting, with a top Justice Department official and FBI agents at Mar-a-Lago, that everything had been turned over, and that it was an informant telling them that that was not the case subsequently that led them to believe that they had to go in with a search warrant. Can they establish some level of obstruction there? Do they have to establish that Donald Trump knew that there, in fact, was material that still had not been obtained?
Yeah, it's a great question, Andrea. So to prove intent with respect to any defendant, you'd have to show that that person, the lawyer, Mr. Trump, an aide, somebody else, intended willfully to do a particular act. And so let's talk about the lawyer. If she knew that she was making a false representation to the Department of Justice, if she knew that and did it anyway, that could be part of the basis of a crime, of a charge. If she did due diligence but didn't do it well, if she thought she was telling the Department of Justice the truth but was wrong, being wrong, making a mistake, is not the basis of a crime. Did someone mislead her? Did she fail in some way to do what she was supposed to do to find out what was actually remaining at Mar-a-Lago? So this is why I think the affidavit is so important. All we have so far is the warrant, the order itself, and then the inventory, the return of items, the itemization of what was taken from the home. But the affidavit itself, Andrea, would lay out the basis for the search, the probable cause. And it would be in that document that some of these questions that we all have would begin to be answered.
And do you believe the affidavit should be released, redacting sources, methods?
So normally, affidavits for search warrants are released. In the normal course of business, we put them under seal, and I was a federal prosecutor for a long time. We put them under seal before we execute the search warrant. And if you think about that, that makes perfect sense. You don't want to tip anyone off that you're on the way. When you tip people off that you're on the way, documents disappear, right? They can be destroyed. People reach out to witnesses, others flee. But after the search warrant, once there is no longer a legitimate law enforcement basis to keep the affidavit sealed, typically you go to the judge with a motion and you ask him to unseal it, and he signs an order unsealing it. So I expect that's going to happen at some point. It may be redacted in part, to your point, But we're going to see, I imagine, most of it, and I hope relatively soon, and that's going to help us answer all of the questions that we have.
So, Andrew, if you were back sitting at the Justice Department and advising the Attorney General on a decision that would be up to him, and you had the evidence that he was witting in all of this, was knowledgeable, would you indict a former president?
So, if the crimes are sufficiently serious and there's precedent for bringing those charges against anyone else, then the answer is yes, because a president and a former president are not above the law. I do think here we may be waiting, though, to see what happens with the January 6th investigation, because one of the questions for the Justice Department is they may be able to make a case with respect to the documents at Mar-a-Lago, but they may decide that they wait and bring one larger case. And I should add, in addition to the former president having issues with the Department of Justice, there are also issues that he's facing in the states. And so I can also see the Justice Department wanting to see what is going to happen in Georgia, what is going to happen in New York, where there is a pending investigation as well.
Chuck, you've said in the past that you should not indict, that there's a rule in the Justice Department, don't indict if you don't think you can convict. Do you think you can convict someone in this polarized atmosphere, a former president, Donald Trump?
Well, a couple of things here, Andrea. First, the standard to get a search warrant is probable cause, a much, much lower standard than you would need to convict at trial, where you would need to convince a jury unanimously by proof beyond a reasonable doubt. So there's a big difference between those two standards, and I don't know that they're there yet. But second, you know, a jury would be impaneled having answered numerous questions and under oath promising that they can judge a case fairly and by the facts adduced in the courtroom and not based on media reporting or our commentary or anything else like that. So can a president or a former president be fairly tried in a United States court? Absolutely.
Well, we have to leave it there. Chuck Rosenberg, Andrew Weissmann, thank you both so very much.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.